The Affordable Care Act asks states to create so-called health insurance exchanges. In return, the federal government offers people with modest incomes subsidies when they buy insurance and imposes taxes on some businesses and people in the state to pay for those subsidies. The law says that subsidies will be made available to citizens who get insurance through an exchange established by the state. But most states refuse to create exchanges, so the federal government set them up instead. After meeting regularly with White House officials, the IRS authored regulations to provide subsidies through federal exchanges as well.
And when it expanded the subsidies, it also expanded the taxes that go along with those subsidies, and right now 57 million Americans are being subjected to those taxes illegally. 2 federal courts have found the IRS broke the clear and unambiguous language of the Affordable Care Act by imposing those taxes and issuing those subsidies in 38 states. This is not a constitutional challenge to Obamacare. This is a straightforward case of statutory interpretation. If it were about anything but Obamacare, the court would rule for the plaintiffs 9-0.
It's not unusual for Congress to provide incentives to states adopting federal desires.
The reason that every state has a drinking age of 21 is not because the federal government commanded them to have a drinking age of 21. It's because they said you will not get highway funds unless you make your drinking age 21. The exact same thing has happened with these state-based exchanges. The federal government told them you will not get subsidies for your citizens unless you create an exchange, and then much to their surprise, many states did not.
The government argues that allowing subsidies regardless of who set up the exchange is more consistent with the purpose and design of the Affordable Care Act, because otherwise the system would fall apart. As Justice Kagan wrote in 2013, we explained in one recent case that Congress wrote the statute it wrote. This court has no roving license in even ordinary cases of statutory interpretation to disregard clear language simply on the view that Congress must have intended something broader.
It's still a story of mandates, right? Basically a government fighting with the fact that it can't just command people and control them like puppets on a string. The individual mandate has to incentivize people, the Medicaid expansion has to incentivize states, and the subsidies to states and exchanges have to incentivize states to create those exchanges, and sometimes freedom means that people will do different things and states will do different things. And one thing you can't have in that situation is a president who just decides to rewrite the law because some states didn't do what he thought they would do.